Hey, so good morning, good afternoon, good evening, wherever you are. This is Alan Burgos from the hashtag Walk with Lan channel. Welcome and welcome back to our channel. All right, so let me just honor our subscribers. They are now more than 3,600. Okay, so we are road to 4,000 subscribers. Okay, and then I'm always praying for you. And today we will be continuing the discussion that we have with regards to the RA 10175, the Cybercrime Prevention Act of 2012. Okay, so we are done with the three chapters, chapters 1, 2, and 3. This time around, we will be having the chapter 4, no, which is the enforcement and implementation. So we will reading this one, and then I will be sharing my insights, no, about this sections in this particular chapter on the point of view of an IT professional. Okay, so the title of this chapter is Enforcement and Implementation. Okay, so section 2, it says here that law enforcement authorities, no, the National Bureau of Investigation, or NBI, and the Philippine National Police shall be responsible for the efficient and effective law enforcement of the provisions of this act. The NBI and then PNP shall organize a cybercrime unit or center manned by special investigators to exclusively handle cases involving violations of this act. No? So there are two law enforcement authorities that are required, no, by law, no, or mandated by law to be the law enforcement agencies. These are the National Bureau of Investigation and the Philippine National Police. NBI is under the Department of Justice, okay, headed by a Secretary of Justice. And while Philippine National Police is under the DILG, but by the way, no, merong NBI may director yan, no? Parang it's like a chief PNP. The same thing with Philippine National Police, meron yung chief PNP. Okay? Now, PNP is under the DILG. Okay? So sabi dito, they are required or mandated to organize a cybercrime unit. That's why PNP meron yung anti-cybercrime unit. The same thing with National Bureau of Investigations. Okay? All right, now let's go to section 11. Duties of law enforcement authorities to ensure that the technical nature of cybercrime and prevention is given focus and considering the procedures involved for international cooperation, law enforcement authorities, specifically the Computer Technology Crime Divisions or units responsible for the investigations of cybercrimes, are required to submit timely and regular reports, including pre-operation, post-operation, and investigation results, and such other documents as may be required to the Department of Justice for review and monitoring. So PNP and NBI, while they are having this office or anti-cybercrime division, okay, so they will be conducting pre, post, okay, or pre, post, and while the crime is the pre post operation and the pre-operation and post-operation investigation reports, no? And then these reports will be submitted to the Department of Justice for review and monitoring. Okay. Section 12, real-time collection of traffic data. Law enforcement authorities with due cause shall be authorized to collect or record by technical or electronic means traffic data in real time associated with specified communications transmitted by means of communication. So I don't know, they are allowed to with due cause. I'm not sure of the definition, but with due cause, maybe with the approval of the proper court. Okay, shall be authorized to collect or record technical or electronic means traffic data in real time. Siyempre, hindi naman basta-basta, parang ano yun, di ba? Yung wiretapping, hindi naman basta-basta yan pag-collect. But of course, with due cause or with approval of the proper court, they could be able to do that. Okay, traffic data refer only to the communications origin, destination, route, time, date, size, duration, or type of underlying services but not content nor identities. Okay. So if they are allowed to monitor the real time traffic data, it will only be allowed for the communications origin, destination, route, time, date, size, duration, or type of underlying service, but not the content itself nor identities. No, but they could be able to identify that. All other data to be collected or seized or disclosed will require a court warrant. Okay, yun. So there is so there is a court warrant aside from this mentioned here. Okay, but if the case is involved with content and identities, they need a court warrant. All right. Service providers are required to cooperate and assist law enforcement authorities in the collection or recording of the above stated information. Okay, so Globe, for example, Globe, PLDT, or any other ISPs for that matter, they would be required to cooperate with the authorities, specifically if there is a court warrant. Okay, the court warrant required under this section shall also be issued or granted upon written application and examination under oath, or affirmation of the application and the witness he may be produced, and the showing that there are reasonable grounds to believe that any of the crimes enumerated herein above has been committed or is being committed or is about to be committed, that there are reasonable grounds to believe that evidence that will be obtained is essential to the conviction of any person for or to the solution of or to the prevention of any such crimes, and there are no other means readily available for obtaining such evidence. Section 13. Okay, so Section 13, preservation of computer data. The integrity of the traffic data and subscriber information relating to communication services provided by a service provider shall be preserved for a minimum of 6 months. 6 months, from the date of the transaction. So if they process it December, so until June, they should be able to finish it. Content data shall be similarly preserved for 6 months from the date of receipt of the order from law enforcement authorities requiring its preservation. Law enforcement authorities may order a one-time extension for another 6 months, provided that once computer data preserved, transmitted, or stored by a service provider is used as evidence in a case that near furnishing to such service provider of the transmittal document to the office of the prosecutor shall be deemed a notification to preserve the computer data until the termination of the case. The service provider ordered to preserve computer data shall keep confidential the order and its compliance. Okay, disclosure of computer data. The law enforcement authorities, upon securing a court warrant, shall issue an order requiring any person or service provider to disclose or submit subscribers' information, traffic data, or relevant data in its possession or control within 72 hours. From receipt of the order in relation to a valid complaint is officially docketed and assigned for investigation, and the disclosure is necessary and relevant for the purpose of investigation. Search, seizure, and examination of computer data. Where a search and seizure warrant is properly issued, the law enforcement authorities shall likewise have the following powers and duties. Within the time period specified in the warrant, to conduct interception as defined in this act, and to secure a computer system or a computer data storage medium, to make and retain a copy of those computer data secured, to maintain the integrity of the relevant stored computer data, to conduct forensic analysis or examination of the computer data storage medium, and letter E, to render inaccessible or remove those computer data in access computer or computer and communications network. Pursuant thereof, the law enforcement authorities may order any person who has knowledge about the functioning of the computer system and the measures to protect and preserve the computer data therein to provide, as is reasonable, the necessary information to enable the undertaking of the search, seizure, and examination. So there is a forensic analysis here. No? Law enforcement authorities may request for an extension of time to complete the examination of the computer data storage medium and to make a return thereon, but in no case for a period longer than 30 days from the date of approval by the court. Okay, so 72 hours And then after that, 30 days. Okay. Custody of computer data. So dapat dito meron tayong documents, no? For custody. No? All computer data, including content and traffic data, examined under a proper warrant shall within 48 hours after the expiration of the period fixed therein be deposited with the court in a sealed package and shall be accompanied by an affidavit of the law enforcement authority executing it, stating the dates and times covered by the examination. And the law enforcement authority who may access the deposit among other relevant data, the law enforcement authority shall also certify that no duplicates or copies of the whole or any part thereof have been made, or if made, that all such duplicates or copies are included in the package deposited by the court. The package so deposited shall not be opened or the recordings replayed or used in evidence or then contents revealed, except upon order of the court, which shall not be granted access upon motion with due notice and opportunity to be heard to the person or persons whose conversation or communications have been recorded. Okay, destruction of computer data, no? So upon expiration of the period is provided in section 13 and 15, service providers and law enforcement authorities, as the case may be, shall immediately and completely destroy the computer data subject of a preservation and examination. Okay? So pwedeng physical, pwedeng logical ang pag-erase doon. Section 18, exclusionary rule. Any evidence procured without a valid warrant or beyond the authority of the same shall be inadmissible for any proceeding before any court of tribunal. Restricting or blocking access to computer data. When a computer data is prima facie found to be in violation of the provisions of this act, the DOJ shall issue an order to restrict or block access of such computer data. Non-compliance. Failure to comply with the provisions of Chapter 4 hereof, specifically the orders from the law enforcement authorities, shall be punished as a violation of Presidential Decree number 1829 with imprisonment of prison correctional in its maximum period or a fine of 100,000 pesos or both for each and every non-compliance with an order issued by law enforcement authorities. Okay, so yun yung Chapter 4. All right. So thank you very much. And if you're not yet subscribed to my channel, please do subscribe now. And I'm always praying that you will be blessed so that you can be able to bless others. Thank you very much and have a great day. Bye-bye.